2 will stand part. The question now is that clauses 1 to 3 stand part.
Mr Chair.
Sue Moroney.
Thank you, Mr Chair. The debate now moves to the title commencement clauses and the Principal Act clause. And I want to point out at the start that normally during this part of the debate people are inclined to come up with witty titles that they think that the bill should be called or that the Act should be called. But this is such a serious issue and such a serious attack on workers' rights in this country that I'm not inclined to go anywhere near coming up with humorous titles for an Act that has no humour in it whatsoever. It is called the Employment Relations Amendment Act, and to suggest that this is about improving employment relations, I think is completely and utterly incorrect. And I noted that in the speech from the throne earlier this week that the Prime Minister characterised this as improving collective bargaining, and nothing could be further from the truth, unless of course the people who it's improving bargaining for happen to be some of the Prime Minister's mates and the employers, and perhaps some of the government's interest in this, because it is going to be those people who have been paid wages from the government who are going to be under the most attack most immediately. But of course, after they have been attacked and after their wages and conditions have been suppressed, then it's going to move on to many other groups of workers as well. Anyone, in fact, who has an employment agreement in place or a collective employment agreement in place will be feeling the effects of this. So there's that group of people. But then there's also the group of people who are not covered by a collective at all, the people who probably don't belong to a union. They have much to fear from employment relations under this Act, because those people are the ones who will start missing out on their tea breaks and their lunch breaks and their rest periods, and therefore will have a much less safer workplace because of it. Mr Chair, the commencement date is interesting in clause 2 of this bill, because what it says is that the Act comes into force 4 months after the date on which it receives royal assent. And for those people who follow parliamentary debate, they will see that that's quite unusual, that normally a bill will come in the day after it receives royal assent or shortly thereafterwards. And I'd be interested to know from the Minister why the period of 4 months has been named in here, because as we've just finished debating in the part 2 of the Act, actually the really dangerous, insidious parts of this bill start before now, before we've even been debating it. That is that if people are engaged in collective bargaining already, doesn't matter when they've initiated it, that very dangerous ability to not even have to come near concluding a collective bargaining agreement will start already. It's started now. The clock is already ticking on that very dangerous provision. So in that context, I'm very much perplexed about why the commencement date is specifically 4 months after the date on which this bill will receive royal assent, because as I say, the most damaging part of this Act will already be in place, and in fact is already in place before we've even concluded the debate. Mr Chair, 4 months after the date of royal assent, I have no idea when the royal assent is going to be, but let's think about some of the collective agreements that are going to be affected by that. Because, as I said before, we've got a number of them happening in the health sector, and I note in particular that the primary health care one is coming up shortly. So the primary health multi-employer collective agreement expired on the 31st of August 2014. Now this collective agreement covers about 3,000 health workers. They are people who...
Point of order.
Far away from the title and the commencement, and I ask that she either be brought back to the very narrow focus of this clause or that we shut it down.
I think it is a fair point of order. The member will come back.
Point of order?
No, it's been ruled on.
Okay, it's been ruled on. So, just so people can understand what the point is that this bargaining is actually already underway. So this is about the commencement of this bill, because the commencement title says that it's going to come into force 4 months after the date. So what I'm pointing out here is that there's a whole lot of bargaining that's all underway that covers large numbers of workers, 3,000 just under this one multi-employer collective agreement. Now that bargaining commenced in September, so the collective agreement expired, Mr Chair.
Sue Moroney.
Expired on the 31st of August 2014. The bargaining commenced in September. The commencement title, clause 2 here says that the Act comes into force 4 months after the date on which it receives the royal assent, but it's too bad really for those 3,000 workers. These are practice nurses actually, practice nurses and receptionists in doctors' practices. It's too bad for them. The commencement date means nothing to them, because Part 2, which we've already debated, means that they're going to be captured by it anyway, irrespective of the fact that there's been this 4-month lag time after the date of royal assent. So I'd be very interested under that set of circumstances to know from the Minister why it is that there is a 4-month period, quite a specific time that's been set aside. Are there transitional provisions that the Minister had in mind that he wanted the parties being employers and employees and sometimes unions? Were there things that he thought that the parties would need to undertake in that 4 months before this Act kicks in? What was the thinking about the 4-month period? I'd be very interested to know that. The good thing, though, is it does mean that there is going to be at least 4 months before anyone can have their right to a tea break or a lunch break taken away from them. So at least 4 months when people, if they want to uplift their legal right to be safe at work, can do so. 4 months left where people can actually have the sort of thing that you have to go back to, the day of Dickens to think about. That idea that people might not get the right to have a tea break. Because that's what's actually, the 4-month period is the only thing that it really saves now in this piece of legislation, is actually saving for another 4 months that right for all New Zealand workers, no matter what sort of workplace they work in, to actually have the right to a break. Now, I know that it's too late for some workers. I know that period will be far too late. I heard yesterday after my debate in the House about the death of a forestry worker, and it was reported to me that when the wage and time records were looked at of that forestry worker, that they had gone days and days and days without a break. Is it any wonder, working in a dangerous environment like that?
Tim McIndoe.
Mr Chair, the member is again addressing neither the title nor the commencement. She has ignored your previous ruling.
Chris Hipkins.
There's two issues that I want to raise. The first of which is that the sole judge of relevancy is the chair, and it is in fact out of order to interrupt someone speaking other than if you are the chairperson of the committee to do so. The second of which is I draw your attention to Speaker's ruling 1, page 115, ruling number 1. When debating the preliminary clauses at the end, members should have some latitude to summarise and make concluding remarks about the issues they have raised during the committee's consideration of the bill. That's a long-standing provision in the Speaker's rulings. It in fact dates from 2003 when it was decided by the Standing Orders Committee, which is a committee made up of all members of the House, and has been reinforced by two further speakers.
Thank you, Mr Hipkins. That is a very fair contribution. I think both members have made good contributions. I think the key word is summarise, and I think if we can do that, we'll be okay. We can't repeat. Sue Moroney.
Mr Chair. So, I think that the National Party are now starting to squirm in their seats about the implications of this bill, because the deaths of forestry workers and other workers in the primary sectors actually is utterly dependent on their ability to have safe procedures at work, and that does include the ability to have, by right, not by negotiation, but by right, decent breaks at work. And that's what the National Party is going to deny them. That is actually what the National Party is going to deny them. Because if workers have pressure put on them to negotiate away their right for these breaks, then that is exactly what will happen. We will end up with unsafe workplaces, and it won't be because, as the National Party were trying to say before, because workers are stupid. It won't be for that reason at all. It will be for the reasons of the fact that we have 40% of our children who live in poverty are in families where there are wages being earned. And when a worker is forced to choose between having a break at work or having a bit more in the pay packet and being able to feed the kids, being able to pay the rent, being able to pay the mortgage, guess what? They have no choice often in that scenario. So this idea about freedom of choice that underpins this piece of legislation is utterly, utterly wrong. It was proven wrong in the 1990s by Bill Birch, who used exactly the same arguments. He used exactly the same arguments. Freedom of choice, he said. Freedom of choice to stop getting penal rates for working Saturdays, Sundays and working long hours. That's the freedom of choice that happened in the 1990s. Exactly that same freedom of choice is going to happen when it comes down to people's meal breaks, when it comes down to their ability to have a rest period at work. That is exactly what's going to happen in some workplaces. And I am going to qualify that statement by saying in some workplaces, but that's why we have these sort of laws.
Chris Bishop. Chair, I move that the question be now put.
Denise Roche.
I'm going to talk to the